Hello everyone, I am Karthik Kumar Agarwal Advocate and you are watching my channel Bhartiya Law. In today's session, we'll be talking about a new topic that is anticipation of a patent. This will be dealt in three parts. So the first part will be talking about the searches for anticipation, that is section 13. The second part we'll be talking about section 18, that is the powers of the controller in case of anticipation. And in the last part, we'll be talking about the instances when it is not an anticipation. That covers section 29 to section 34, which is covered under chapter 6 of the Patents Act 1970. Now, to start with, first we need to understand what is anticipation. So, in simple understanding, anticipation is something which has been anticipated or which has been known to the public or known to someone, so that someone could just anticipate it or someone could just know that thing can happen. So, as per the patent law, as per the different definitions, anticipation is something which is the prior invention or disclosure of the claimed invention. So, if you have made a claim today, in or if you have filed an patent application today, but that particular thing was known at a earlier stage, or someone has disclosed it in any of the publication, that can be a patent literature or a non-patent literature, then uh, it is an anticipation. So this can be some by someone else or by inventor himself. When can it be by inventor himself? When it is for example, some inventors have that habit of marketing it prior to making an application. And that can also come under the anticipation because that has now come into the public domain. So all these instances come under the anticipation. Now, when we talk about Section 13 specifically talks about the searches for anticipation by previous publication and prior claiming. This is one of the important sections in the Patents Act from the examination point of view, a patent agent exam, or from your normal understanding also that how anticipation works. So, when we talk about Section 13 subsection 1 talks about the complete specifications when the anticipation is by publication of the complete specifications. And subsection 2 talks about non-patent literature. So we'll be covering that in, I have just made a point over here, which has been circled in red. So if it has been anticipated by any publication before the date of filing of the applicant's complete specification. So, for example, on 1st June 2022, you are making an application, but the another literature, it can be a patent or a non-patent literature, it can be a complete specification of a patent, and it has been made, uh, for example, on 1st of April of 2022, then that will come under the anticipation. Your application would be anticipated by the 1st April 2022 application. But if it has been published, although it can be made prior to your application, but it was not published until then at the time of making your application. So, for example, if an application is made on 1st of April 2022 and you are making an application on 1st of June 2022, then that particular application would not anticipate your application. That might get, because that has not been published yet. If it is published before making of your application, then that would be an anticipation. Now, the third subclause of Section 13 talks about if there is any amendment to your complete specification, then that complete specification will also have to go through the same route of searches and anticipation checks. So that has to be examined in the same manner as that the original specification. And the last clause, that is a subsection 4, this one, examination does not warrant any validity of the patent. So if you have made any application and it has been examined and it has been cleared, your certification has been granted, but that does not warrant the validity of the patent. That can still be revoked in the court. We have seen a lot of cases going on. I practice in Delhi High Court, so I have seen a lot of cases related to patents which have been granted and later on that have they have been revoked by the court. That revocation can go under Section 64 of the Patents Act. So the Delhi High Court, not only Delhi High Court, but any of the High Court has the power to revoke that patent if that comes under the lawsuit. So the examination does not warrant the validity of a patent. I hope this video is clear to you. This particular section 13 is clear to you. If you have any doubt, you can always drop your questions in the comment section below. Moreover, I'll be dropping my email ID and the phone numbers in the description. So you can always be in touch with me for any of the doubts which you have faced. Thank you.